So a federal judge blocking an executive order from President Trump that would stop federal prisons from giving transgender inmates hormone therapy. The judge saying that the administration did not provide a, quote, serious explanation to justify the order. Fox News contributor and GWU law professor Jonathan Turley joins us now. Professor, thanks so much for joining the program.
Thank you, Lawrence.
So there was a lot of things that I was reading the opinion from the court that I found interesting. One was this use of the word personal anguish, and that the fact that the state has to offset that. That was that's not really a constitutional argument, right?
Well, a lot of citizens have difficulty with this, and I think many in Congress would like to see this changed. The problem is it may be difficult for the Trump administration to dislodge this in court because you have medical recommendations to deal with what is called gender dysphoria. Mm-hmm. And these doctors have submitted material that says, look, this is a legitimate mental illness, and if it is, then you have to be able to treat it while in prison. That may be difficult to dislodge as it goes up on appeal. It may require Congress to intervene.
Did the court get too political, though? One of the statements from the court was democratic self-governance does not mean blind submission to the whims of the most recent election victor.
Yeah, I agree with you. I felt that the opinion drifted into hyperbole, and this is a problem we're seeing with a lot of judges, where they are essentially virtue signaling through their opinions, and I think that's a terrible mistake. If you want to say, look, this is a mental illness and we've got to go with the recommendation of the doctors, I can understand that. One can disagree with it. Maybe Congress wants to do something about it, but I don't think that this is a license to have language of that type.
Well, Professor, it goes to the larger conversation, which is 2/3 of all of the injunctions made ever against the president has been against Donald Trump.
Right. No, it's extraordinary. You know, Alexander Hamilton referred to the judiciary as the least dangerous branch, but the framers didn't have national injunctions. They weren't aware that judges could effectively micromanage the executive branch. You know, we recently had a Boston judge who had just a month earlier been effectively reversed by the Supreme Court. His injunction was at least lifted in what was a very controversial order to pay out grants that the administration thought might be fraudulent or wasteful. Well, 1 month later, he was back with a new national injunction saying that you couldn't make changes in the Department of Education. We have a new San Francisco judge who just said that the president cannot do reductions in force, which is a classic role, a classic priority of presidents, particularly Republicans, saying that these are just too great and I'm not going to let you do it. Those raise really troubling issues. That is intruding rather deeply into Article II presidential powers.
Mm-hmm. So, Jonathan, I only got about 30 seconds, but hopefully you can give me an answer to this. If the framers didn't intend for this to happen, what is the legal remedy?
Well, you know, Lawrence, that's exactly what we are waiting for from the Supreme Court. They had an argument in the birthright citizenship case to look at national and universal injunctions. They also have that case in front of them where the Trump administration is saying, we have a right to do reductions in force. We have a right to reduce the size of the federal government. We're waiting for those decisions. And I got to tell you, we've been waiting too long for the Supreme Court to bring clarity to this area.
Way too long. Professor, thanks so much for all your knowledge.
Thank you, Lawrence.
I'm Steve Doocy.
I'm Brian Kilmeade.
And I'm Ainsley Earhart. And click here to subscribe to the Fox News YouTube page to catch our hottest interviews and most compelling analysis.